Hello, everybody. We have a very, very interesting discussion ahead of us. So let's start in advance in order to be able to use this time. And I'm really sorry because I knew there would be huge interest for this panel, and unfortunately the room is very small. I don't know why we are such a small room, but probably there is some possibility to sit near the wall if you don't want to stand up or on the stairs. And in any case, this panel is recorded and will be very soon available on YouTube. Sorry for these conditions. It's very warm for us also, especially taking into consideration the very hot issues that we will discuss. And as a matter of fact, I am Professor Theodore Christakis, and I'm very glad to moderate this panel. And I hold the AI-regulation.com chair at the Multidisciplinary Institute of Artificial Intelligence in Grenoble, and I'm very happy to announce that yesterday night, the President of the French Republic announced that our institute, the MII, where we're doing fantastic research on all AI issues, has been selected to be an AI cluster. You know that France is investing heavily. Thank you, thank you. I created this with Dali to celebrate. As a matter of fact, there will be a lot more panels thanks to this, and we have received huge funding by the French state, 70 million euros. In order to continue research on these issues. And I'm very proud of my colleagues at the University of Grenoble and the ecosystem in France. We have a representative here also of France, but it is the regulatory view, the head of AI, Félicien Vallée. We have two representatives of the industry from OpenAI, Jessica and William from Google, and we have the practitioner's view also from Jan, who also wants to remind all the time that he was also on a DPA, but this was long ago, before he sold his soul to the devil. As a matter of fact,
I have another call, sorry.
So we have, I don't know how I should do with this slide. How can I put the next slide, please? Does not seem to work. Can you help me? Oh, okay. So here in the panel, well, I don't need to make a lot of introductions because you all know that this is an extremely interesting topic. You all use ChatGPT, Gemini, Llama, and the other guys. And as a matter of fact, there are a lot of extremely interesting legal questions. And we wanted to make this panel interesting. We don't want to repeat things that you know, that you see written here and there. We wanted to address a series of new questions, hard questions, that even ChatGPT and co cannot really answer. And we will see here if our human dream team, because this is a real dream team, will be able to do any better than them. Jan responded on LinkedIn, we're just humans, unfortunately. Yeah.
I'm former regulator, and French, and lawyer, so nobody's perfect. I'm sorry.
Yes,
the answer is going to be awful.
This is the problem with humans. You can never get perfection. But as a matter of fact, we will try, and we will open the questions one after the other. You know, of course, that there is a lot of thinking. And what we would like to show here also is all this thinking that is being done by different stakeholders. The DPAs are thinking very hard on all these issues, and the regulators, the legislators, as has been seen yesterday, the Council adopted finally the AI Act, and we'll discuss also with the interactions with the GDPR. Thinking by the industry themselves, with whole teams working both on the technical and on the legal issues, on these hard questions, by practitioners like Jan and all you lawyers here, by academics like me and all my colleagues who are working on these issues. So these are very difficult issues. It's not black and white, and don't believe people who tell you that it's black and white. And one of the objectives of this panel is precisely to show, to engage in a very constructive discussion, to show show how difficult these questions are and why we need to do this collective thinking on these new questions in order to be able to protect privacy, data protection, other fundamental rights without hindering innovation and depriving us precisely of the possibility to generate images like this one upstairs with the GPTs who are really puzzled with the questions that I'm going to ask here. You know that we have a lot of regulatory action that the Garante a year ago started by prohibiting, by suspending, ChatGPT because it raised a lot of questions concerning the GDPR. There are a lot of other investigations, complaints, thinking about guidelines. The EDPB task force, we're going to talk about all these issues. And at the same time, we see that private companies really reacted to all this. So this has already a lot of effects. And in our chair, we have been following very closely all the action by DPAs, but also the reactions by private companies. And we see all these private companies, OpenAI, Google, Facebook with Llama, and others, all of them who are present in Europe, revised several times their privacy policies in order to respond, to react to this kind of actions by DPAs. All this is new, of course, it requires some time, and this is why it's extremely important to have the discussion we have today. I don't want to spend a single more minute because I would like to precisely to be able to have the time, and I open our first question, which is precisely focusing on what the data protection authorities are doing. And if you see closely, you will see there are plenty of DPAs working on these issues. We do have the EDPB task force, which is supposed somehow to unify at least in Europe, but at the same time, we see guidelines a few days ago by the Dutch DPA. The CNIL has already published in France, a huge set of very careful and prepared for a long time guidelines. And Félicien will say next week we will have another set of consultation. Other DPAs in Europe, I will not sum it up. The ICO, who is here also and will be very happy, it will be the Clara from the ICO will be the first person who has launched some extremely important consultations, and it seems they have received thousands of answers, and she will talk to us about this immediately afterwards. So we have this proliferation, and somehow also we see some divergences on some issues already appearing. I will come more to the topic later to compare, for instance, the guidance of web scrapping by by ICO, the provisional, very provisional guidance, and to compare with the Dutch DPA, who adopted a much more strict position on all this. So, as a matter of fact, the first question that I would like to ask to our panelists, and of course I will start with the DPA, are proliferating guidelines by DPAs a problem or a solution? And what could we expect as harmonization coming from the EDPB on this field?
Okay, thanks a lot, Theodore, and very glad to be here today with you. And actually, it's pretty impressive. This room is really, really packed. So glad to try to answer this question. And being a DPA, it's not necessarily the best. I mean, I'll give the answer that I have. So first of all, is it a good problem solution? In our point of view at the CNIL, we believe that it is actually a necessity to provide answers to secure both individuals that are affected by this data processing, and also to secure the AI community that is providing these tools, and offer them a framework in which they can actually securely know what they can or cannot do, and this is, we believe, essential. Then, I indeed hear the remark of Theodore regarding we have. And we see it at the CNIL also, because obviously we try to read them all. Of course, we see quite a lot of guidance, recommendations, a lot of production regarding Gen AI, and mostly indeed at the national level, and with various positions. And we do it, as stated by by Theodore. We believe it is a necessity, and also we believe it is interesting to process this way for this very particular topic at least, because we need quick answers, because working at a national level helps us with that, and we can actually give food for thought and build actually the European framework that should emerge from all these positions. Because we also know that adopting a position at the European level is quite complicated. It depends on various factors, and getting to an agreement between 27 representatives, obviously, it's complicated. So it can take more time. So you have this kind of two-level actions at play on the national one, where positions are forged, and then on the European level, well, you will find room for negotiation. But obviously, interestingly, you'll find also a lot of convergence between the positions of DPAs, and also we try to talk to each other, to engage, and to understand the views our colleagues they have. So that's the first element of answer. I wanted to be a bit more, give more information about the work we've been doing at the CNIL for those interested. So as stated by Theodore, we started in last October with the publication of practical how-to sheets focused on the development of AI systems, so solely on the development phase, and how it should be done to correctly work with GDPR principles. So we've done this. We put this in consultation, similar as what the ICO did, for instance. And then we received quite a lot of answers and adopted recommendations at the beginning of April. So definitive validation. And now, in the coming days, as said Theodore, we will release new material with very complicated issues that we try to tackle regarding, and we might discuss this further later on during the panel, but regarding legitimate interest and how you can mobilize this legal basis, and more specifically regarding web scrapping, also guidance still put into public consultation regarding open source. That is quite an important question, and also regarding information of data subjects, exercise of rights for individuals, and other aspects such as security and annotation. Plus, also so this is more guidance that we want professionals to read and to react to, and we also plan to produce an open questionnaire about AI models, and in fact, how should GDPR apply to them? It is very, very complicated question, because as you know, machine learning models, they can show some memorization, regularization capacities. So how should GDPR apply to them? And well, this is still very open, still very in the air. We didn't want to publish something just for comment, but we will publish a questionnaire. So in the coming days, so stay tuned.
Thanks. And what about the DPB? When should we expect a guidance, a harmonized guidance on these issues, and what kind of outputs we'll have from the ADPB?
Well, you've got various actions engaged on the ADPB level. So as you said, following the Garante action last year, there was a ChatGPT task force that was created in order to somehow gather together all the complaints that DPAs could have regarding these cases, and try to find and at least harmonize the positions. But it's full of questions, quite complicated, so this work is still ongoing. And you have also other productions that are in their way. So one regarding, and we might also touch this subject a bit later on, one regarding the interplay between GDPR and the forthcoming AI Act. So how this will play out, the two texts together, and another one that should follow. I believe that is not started yet. Should be started. I mean, that's the plan at least regarding web scrapping. So where we could have a consolidated view of what DPAs think.
Thanks a lot. Jan, as a practitioner, a problem or a solution all this guidance is coming?
Well, you know, I think this guidance, they are the results of two things, I would, to summarize. I mean, first is the capacities of the DPAs. They are not equal. Not all the DPAs have the resources in terms of IT people like Félicien within their staff. So it's capacities, maturity, and it's also the political will of the head. And you can see, you can also analyze the different guidance we have in light of these criteria. You have the usual suspects that are, you know, playing the game, like CNIL, the ICO, which is not in the EU, but still have a tech capacity important. Spain had traditionally one, and the Netherlands. So that's the first line of explanation. Why do we have that? Because what I'm interested in is why some do things and some don't publish guidelines. I think it's interesting. The other layer of analysis is that I think there's a kind of hidden political agenda behind these various guidelines or their absence. I mean, DPAs, I think they are quite concerned, if not obsessed, by the AI Act and the provision with the AI Act that says that there must be a supervisory authority and a market surveillance authority, and many of them want to be appointed at the member state level as this authority. And if you have a look at the landscape internally, it's not granted for many, and you've got different choices already made. Like in Spain, they decided to create a dedicated regulator for AI, a bespoke one from scratch. In Italy, they appointed kind of two regulators. One is on the identity, and the other, I think it's kind of telecom, etc. So the DPAs, they're also playing a game to position themselves in this game with this uncertainty about who's going to be appointed. And, you know, it's like, you know, in a good series, there's good cop, bad cop. I mean, the bad cop definitely has been the Garante last year and very recently, you know, taking very enforcement approach, quite repressive and aggressive in order to convey the message that they're going to be, you know, very protecting the rights, etc. So that's a bet. You've got other DPAs that have a more, let's say, good cop position. I would say, well, the ICO is out of the EU, but definitely the CNIL. CNIL is about to launch its third round of public consultation, so they're definitely positioning as an authority willing to construct, you know, build with the profession, with industry, some guidance, keeping independent, but, you know, and also the German DPAs. This, you know, the DSK, which is the federation of the DPAs within Germany, there are 17, did, you know, make the statement. They said that they have the knowledge, they have the technical expertise and the experience, so they should be appointed at that. So I think it's also, you know, there's also a lot of, you know, stake for authorities, and there I can see also that this is one of the explanations of these proliferating guidelines at the national level, because the national level will be the one that will decide who's going to be the authority under the AI Act.
Thanks a lot. Good cop, bad cop. We'll come back to it. And what about the industry? How do you find all this? William, let's start with you.
Yeah, maybe I'll start with industry's responsibility and then double back to DPAs. So we are launching products in the market. We are accountable for the compliance of those products. That's why when Google launched our Gemini product, we briefed our lead supervisory authority. It's why we took feedback. It's why we paused our launch to incorporate some of that feedback. It's why we've published an overview of transparency, which you can look at on the site. It's why we shared our data protection impact assessments for the Gemini product in their entirety and our legitimate interests assessments in their entirety with our lead supervisory authority and other concerned data protection authorities across Europe. We've got responsibility to drive what we think compliance looks like, and then we've got a responsibility to listen to the voices in this room and adapt as we go. And I have to say, I think DPAs have done a kind of incredible amount of work, are moving at incredible pace, and are actually putting a lot of resources and time into getting this right. The GDPR is designed for situations like this. It's designed to promote harmonization, but there are lots of tools in there we need to explore: certifications, codes, seals, other ways to get the job done where industry has a role. There's also technological proliferation. There's sectoral proliferation. What's right for tech might not be right for healthcare or finance or manufacturing or transport. So there's complexity here for regulators to work through. But we have industry has a role, civil society has a role, and I think DPAs are doing the work and using the mechanisms in GDPR to get us there. My one note of caution is that this is a moment where technology is advancing at pace. You'll hear us at Google talk about being bold in the moment to deliver the benefits of the technology for society, for our users, but also being responsible. What we need to do is make sure we're working together to get answers fast. There's always a role for enforcement. Enforcement is an important tool in the regulatory toolkit, but I would say that enforcement doesn't produce super fast scaling effects, and this is a moment where we need super fast scaling effects. So I think the fact DPAs are engaging in this guidance, this cooperation is to be welcomed. The work so far is to be welcomed, and certainly from a Google perspective, we're happy to be open and transparent, happy to have our homework marked, and happy to adapt as we hear from voices across the regulatory community and many in this room.
Great. So OpenAI is first and foremost a research organization. So from that perspective, we have greatly appreciated the guidance from DPAs, including DPAs with technical teams who are engaging with the issues in a very sophisticated way, as well as the opportunities for consultation. I think sometimes one of the best things that we can do is to listen, hear the feedback, and understand the perspectives of experts in this field. And then we also have an opportunity to share how we're thinking about things, as well as the current state of the technology, the current state of the research. Because as much as we constantly are working to improve our models, we're also constantly improving how we train our models. And so those are ongoing research projects that we do continue to engage with the regulatory community on as well.
Okay, thanks a lot. For the time being, humans are doing pretty well, I think. Good.
Wait.
Wait and see, because there is a hard one coming now. Can legitimate interests justify using personal data to train LLMs? So this is a very critical question. So we start focusing now on 4 specific GDPR questions. The 2 first, including this one, concern the training of LLM data with data, and the 2 others that will come later will concern the outputs. And as a matter of fact, when we're talking about training data, we're focusing here on a specific issue. You know that all these models need a huge amount of data. We're even saying that they're running out of data. They are collecting everything that they can find, or almost everything, in order to become good. And as a matter of fact, among the things that they're collecting, they're not targeting specifically personal data, but among things that they're collecting, they're also collecting personal data. I don't know out there how many percentage of the data existing are personal data, but it could be, I don't know, 30% or 40%, or I don't know. And they also collect personal data. So we will not discuss here at all issues that might be easier to address under the GDPR, such as the training by users' prompts, user-generated prompts. As you know, also, most of these models permit to exclude, not to use the prompts that you personally, when I use, I always exclude this possibility. We're talking here about web scraping and getting all this data out there, where, of course, legal bases such as consent are entirely inconceivable. So the big issue is the issue of legitimate interest. It is exactly this legitimate base which appears in the different privacy policies. We have worked in our chair and consulted all the privacy policies of Google, OpenAI, Facebook, and the others. It's legitimate interest. And this is also the legal basis that has been used, for instance, for indexing in search. You know that we already have this problem in the context of, for instance, Google search or the others, because they are scrapping data, including personal data, in order to be able to give a response when you put my name to Google search. And the legal basis that has been accepted is legitimate interest. There are a lot of parallelism to make eventually with legitimate interest. One of the objectives precisely also of this question is to try to see what is alike, what can be compared, and what cannot be compared, because we know, for instance, that both the court and DPAs have adopted a very restrictive view on legitimate interest in other contexts. I will ask later, for instance, about position of the CNIL, Félicien. But it seems to me that some of these contexts are entirely different and cannot be compared. You cannot just transpose what the court said in a specific case about pay or consent, or what the CNIL said about Clearview, for instance, for different reasons. You cannot just transpose it here. So the big question that we have also the guidance already appearing here. We have seen, for instance, that the ICO in this very provisional guidance has adopted a flexible approach on legitimate interest, of course reminding the three-part test, but eventually recognize it that subject to some conditions and risk mitigations and safeguards, eventually companies could use legitimate interest, and you will correct me if I'm wrong in my understanding, what I saw a more flexible and open approach in order not to hinder innovation, while, for instance, if you take the recent guidance by the Dutch DPA, you will see a very strict approach, which does not close the door either. They just say that, for instance, you cannot just justify this on the basis of commercial interest, of making money, which in reality what they say as other purposes like fraud prevention, improve the security of your computer system does not lead us so far, but eventually the interest of humanity of having generative AI models could be something, as the court said in Google Spain, which could also enter into the interest of the public. And the Dutch DPA also creates a second obstacle, which is says even if it is possible, you must inform the data subjects. How are you going to inform later the data subjects, a billion of persons, about the fact that you collected their data? So I would like to get the input, first of all, also of the industry eventually. William, do you think that precisely there is some parallelism to make with the research engines and the precedent of indexing? And what do you think about legitimate interest as possibility?
You know, look, the GDPR helpfully reminds us in one of its recitals so that data processing should serve mankind. It also helpfully reminds us that data protection is a qualified right to be balanced with other rights. And we have to, when starting this conversation, be cognizant of the massive potential of this technology, not just for commerce and industry, but for public services, for coming up with solutions to healthcare challenges, environmental challenges. So I start from that premise that we need to be bold in the moment, but I also recognize we need to be responsible, accountable, and comply with the law of the books. I'm very optimistic about the ability of data protection regulators and the courts to get us there. Why? Because I've lived that journey. I've been at Google for 13 years, and I remember all of the issues about how do you provide notification from a Street View car. There's some very amusing cartoons published in press. But in the end, companies, regulators and the courts found a solution that preserved the rights of individuals, delivered appropriate notice and protected individuals' rights. Similarly with Google Spain, the Castilla case, where we had similar questions about the nature of the basis for processing for web indexation, and the court found a way to protect the rights of individuals, to ensure that companies were accountable as data controllers, and to get to the type of balance that both the Charter and the GDPR have in mind. So I'm optimistic that we will get to the same outcome and the same conclusions here. I accept that the public interest considerations are different and that it's more complex, given that we have a proliferation of models used for different purposes. So I accept that, but I think the legal framework and the regulatory framework to tackle this together is there. What I would say is, again, in the interest of being completely open, transparent and accountable, Google does rely on legitimate interests for the collection of data from public sources for the purposes of training large language models. We have completed the appropriate documentation, shared it with our regulators, And that, as a necessary part of that process, we have set out and critically evaluated the range of safeguards we have to have in place, some of which, I'm not going to touch on it now because we're going to cover some of that in the context of other questions. So what I would say is, yes, I believe legitimate interest can be an appropriate legal basis. That demands a high standard of rigor and accountability documentation. It requires us to be transparent, and it requires us to demonstrate the safeguards that we have in place. So, and with that, again, if you look in your packs, you have an overview of some of the safeguards that we've put in place for the Gemini model. I'm not saying that's the end of the chapter. There's lots of research going on into areas like machine learning we'll come to later. But I'll pause in the interest of passing the floor to other panelists.
Jan, as a practitioner, do you think that this will work?
Well, I'd like to answer this question with a question, which is a traditional lawyer's trick. I mean, what else? What else? I mean, we are talking about training data, so, web scraping. This is what we're talking about. Is consent an option? I mean, it's impossible technically and legally impossible. Performance of the contract, it's impossible either. So legitimate interest is the most pragmatic and the only available solution for private companies to go on. But then, if it's not the only solution, then I'm a bit concerned by some things you've said, Theodore, and I agree with you. Like, I see the divergent approaches within the EU, and the Dutch DPA position on web scraping said that commercial interest is not sufficient as a legitimate interest, but what companies do commercial activity. I'm sorry to say, but I mean, I've been told in my very early years as a student in law that, the very object of a company is to do profit and to have commercial activity usually. So if it is not a legitimate interest, what else? And then you not mentioned that, but then they sent a preliminary question to the ECG on that one. So the ECG, once again, going to provide some guidance on that. And it has provided some very pragmatic guidance. So then, in light of this, concerning approach, I think the ICO and the CNIL understand a more pragmatic and more flexible approach. The ICO said that they acknowledge that business interest is a legitimate one, societal interest too, and everything is about, since it's invisible processing at the training stage, the focus, the discussion will be about safeguards and transparency. That's traditional, and we are all here privacy experts. We know that when we rely on legitimate interest, we have to do this balancing exercise, rights, etc., and risks. And here, safeguards and transparency is going to be the focus of the upcoming, regulation and guidance from the DPAs. And in that regard, the CNIL's guidance is very interesting because, they say that it's even possible to collect sensitive data, which I think, it's true because like search engine, they do collect, not willingly sensitive data, but since they're web scraping the web, there are some sensitive data about political opinion or sexual orientation, even criminal data. Offenses are indexes and the model is trained on that. And the criminal data is even more restrictive as a legal regime under the GDPR. And, the CNIL said that the reference to the ECG case on the right to be forgotten of 2019, because this question, they were sent to the Court of Justice in the framework of the search engine, and the comparison is very interesting. They say that the ECG didn't say that the prohibition of Article 9 or Article 10 of the GDPR did not apply. Did not say that. They say, well, it applies in the framework of the competencies and the capacities of the search engine. And I think that's very promising because it's a very pragmatic. You cannot, of course, expect a search to inform everyone about the fact that the data is collected. It's when at the training stage it's impossible. So the discussion is going to be later at the output, but we have a question on that one. So I just wanted to highlight that the journey William referred to, the right to be forgotten, I think is full of interesting lessons in our discussion today. Many comparisons can be drawn, and so it provides some optimistic solutions in the near future, but it means that there's going to be litigation anyway, which is good news for a lawyer.
Okay, 2 out of 2 defending legitimate interest for the time being. I don't think that you will object with them, Jessica, from the OpenAI point of view.
That would be correct. I'm not going to object. Maybe I'll just touch on some of the specific elements that we were discussing. So in terms of the interest, for example, we would come from like a mission-driven purpose, the goals of fostering research, building safe and reliable technology that benefits all of humanity. And there are many, many reports of the ways that people can use these products for good. People can use it to support their writing, conduct research, coding, it assists the visually impaired, helps with translation, brainstorming creative ideas, lots and lots of very useful purposes. But to do all of these things, the model would need to learn what personal data is and how to use it, for example, in sentences. So, for example, if a person is using, a person with dyslexia is using ChatGPT in order to write professional-sounding emails to clients, it would need to be able to understand how to incorporate names into draft text. So that would be an example of how it would need to kind of deal with that kind of information. But in the course of doing that, it is important, and again, this is consistent with principles of privacy by design as well as legitimate interests, you need to build in the safeguards, and we'll discuss more of those later, but obviously it's important to incorporate those safeguards at every step of the process, including training, including deployment, in order to follow privacy by design. And I guess consistent with our role as a research organization, as I mentioned before, we publish a great deal of research publications, including detailed system cards that describe things like the risks that we've identified, as well as the safeguards that we've implemented, and that obviously also consistent with the principle of transparency.
Okay, now we come to the DPA's view, and we have seen that the CNIL has been more reluctant than the Dutch DPA to engage immediately. We have seen you have published your first sets of guidelines, and you have voluntarily, although you talked about legal basis, voluntarily kept the legitimate interest issue to think about it more, and it will be coming in the following days, as you said. So I wanted to ask you also your view. I know that it's work on the making, and you cannot eventually say a lot of things, but I would like to ask you also an additional question, which is precisely the comparison, because we know that legitimate interest has been extremely criticized in other contexts. In the Meta decision of July 2023, the court killed legitimate interest. But in the specific context of targeted advertising, which was just about personal data and profiling and things like that, I don't think that the context is the same, personally, with the issue that we're discussing now. And similarly, for instance, we have seen that the CNIL has adopted a very strict position against legitimate interest in the Clearview case. But once again, in the Clearview case, we had a company which was not only targeting only personal data, collecting, web scraping all the photos of persons that they could find on the net, on social media and elsewhere, but also doing even worse, which was transforming this to biometric data. So once again, this is something very specific, and it's not comparable to a situation where we do web scraping in general of data, including incidentally personal data, where eventually the harm to the individual from this could also be more limited. So what do you think about these issues? And I think it could be good also to discuss this comparison, because otherwise people have a tendency to say, let's just transpose Clearview here and we cannot use legitimate interest. But this eventually, we need to compare apples to apples and oranges to oranges.
Okay, thank you very much, Theodore, and thank you for this recap of the Meta and Clearview cases. Indeed, we believe the purpose that guides the processing is actually paramount in deciding whether or not a legitimate interest legal basis can be mobilized. Regarding the application of this legal basis for the training of AI systems at large, even further than large language models, we do believe, and this will be available with further explanations in what we will publish in the next days. But we do believe at TechNIL that it is most of the time one of the most suited legal bases to do this act of training an AI system. Obviously, when you talk about web scraping, then once you say that, you say, well, what about how do I apply this legitimate interest? And what we do believe at the CNIL is that actually legitimate interest, it really somehow encompasses the spirit of GDPR between having on one side the possibility to innovate, to create things, to do the data processing that you want to, and on the other side to have really important safeguards for individuals and to make sure that they can exert their rights. So actually the question to me is not really whether or not it is possible to have legitimate interest on a legal basis, but how do you tune it? What makes it acceptable? And more specifically then, when you talk about web scraping, what are the safeguards that you make sure to have in place? So we'd say, yes, web scraping, it is possible, but then it must be tightly framed to be done. So we'll provide some examples of safeguards that we see, but for instance, listing the website that should be excluded from the data collection, having only web scraping only data from open, free and freely accessible websites, having some anonymization or pseudonymization measures, so on and so forth, respecting robots.txt or AI.txt files, But I think the crux of this issue really is the information of individuals, even before the exercise of rights. It's my personal opinion, but because at the same time, people are now, in particular since ChatGPT, more and more aware that their data can be actually accessed and web scraped and used for the training of AI models. But at the same time, they do not know really much more than that, and how to get some more information on how, and then further how to exert their rights. So I believe there is really something to be built about how to construct a point of entry, a good comprehension of the data of individuals that are being processed.
Okay, this is fantastic, and we're very much looking forward to read about the examples that CNIL will give. And the ICO also suggests to implement technical and organizational measures as risk mitigations and safeguards. So the two positions seems to meet there. And precisely talking about this is the third question, which is very much linked, of course, to all the things that we discussed. Some people said, okay, you can scrap personal data because it's important, they need that. But if you do so, you can immediately anonymize them or pseudonymize them. So, and there was a panel, I think, this morning also more generally about anonymization in the context of AI. We know that it's a more general issue, but specifically here it could be eventually. So I wanted to ask, and Jessica, I will start with you. Is it possible? First of all, technically, of course you're a lawyer, but you have all the discussion with your teams there in OpenAI. Is it possible to do it? And if you do it, what will happen? For instance, how are you going to anonymize or pseudonymize my name or the name of another person here, and while at the same time making the distinction with a historical figure, for instance, or with anything else, so that the LLM would still be able to give information about historical figures or about things that could be useful to users. Do you think that anonymization, pseudonymization, how do you see internally these questions and eventually other risk mitigation measures?
So I guess what I'd say is that, so our goal is to build helpful models. In order to do that, they need to learn about the world, but they don't need to learn about private individuals in detail. So like I mentioned, they do need to learn about names and how to use them in sentences. But there are steps that you can take and that we are taking to reduce the processing of personal data in our training process. But that is a very currently multi-layered set of safeguards that are carried out throughout each stage, both in terms of training as well as at deployment. So for example, there are various filters that can be applied, and it can also be trained not to provide private or sensitive information about people in response to users asking for private or sensitive information about people. But we are continually researching the various techniques, things that are going to help us build these helpful models that still are able to learn a great deal about the world, but trying to reduce the processing of personal data. So we haven't published a lot of things on this yet. I mean, some of the steps, obviously, we've already included in many of our system cards, but that is something we will continue to do as we research these areas.
And Felicia, in your work in the CNIL, and we know that you have also a very constructive approach with sandboxes. You're working with companies, they ask you these questions. In Paris, where we have some companies like Mistral AI and others. So do you think that this is something that can be done in general? Is it a solution? Is it technically possible? What are your thoughts after all these discussions?
I believe it is a viable approach, and then it should be declined according to the purpose and the specific case in which it is that is explored actually. And this is, and also to agree with what Jessica said, it is one among other measures that should be applied. But then yes, I believe this either data synthesis or data anonymization or data pseudonymization should be explored. In some cases, some won't be applicable, won't be of interest, because that would actually wouldn't fit with the purpose that is looked after. But in some other, it should be of interest, because also obviously, what we try to, if we focus on the object here, is large language models. What we want to have here is actually a representation of what languages are, how it works, and not necessarily having informations about individuals. Like, I mean, every like any you, me, or people that are not necessarily public figures or whatever. And so we do believe that for this, pseudonymizations should be looked after in particular. We also understand that is a complicated issue technically, because, well, first of all, pseudonymization of textual documents, it's complicated. It's not just removing names, first name, last names, but it can be go much further than that. And also, when talking about the volumes of documentation, you have to rely on automated tools for this task that can also be error-prone. And then you have somehow to see how you will tune this and what is actually acceptable in regard to the purpose you are pursuing for this. So I believe anytime this objective of having anonymization or pseudonymization should be looked after. And as you said, we at the CNIL, because this is kind of very theoretical discussion we're having here, but we should also remind that there's some very practical things. And for instance, the AI community, it's a lot of actors, and actually some people are doing the data collection, the web scraping, for instance, for the common crawls and other giant bases, and some other will reuse these databases and fine-tune them, or refine them, annotate them, and so on and so forth. And so we have also something that's very important is to see how the continuity of responsibility, the chain of responsibility between all these actors is performed, and that everybody at his own level is doing the right thing. So, for instance, regarding the accompaniment that we provide to companies, we've been working with with Hugging Face company. So that's a company that provides tons of AI models, AI data sets. So it's very central in the AI ecosystem. And, well, what we try to push them to do, and we will see how it works, but with their central place in the market, to say if such an actor that actually is a hub for the ecosystem can push with good measures, good practices, such as providing tools for identifying names, places, whatever you can find in textual documents, then it can serve also other actors in the ecosystem to build better and safer tools, AI tools. So that's what we try to do.
Very interesting. Thanks a lot. I hope you will agree with me that our humans are still doing very good and better than LLMs. But let's now go to outputs, and here things might get complicated because we will ask a very tricky question. Now we move to the output. So the model has already done the training, and there is a filter there. And then we have the output, and one of the major questions, of course, is the issue of the principle of accuracy, the GDPR principle of accuracy, and the relation with what ChatGPT, Gemini, and Llama and the others respond. You are all aware of the fact that a few days ago, none of your business asked the Austrian DPA to fine OpenAI because it guessed wrongly the birth date of a celebrity. And eventually, one could think that this was not a very huge harm for this celebrity, but as a matter of fact, these are things to discuss if the harm matters or not. But I think that this is an extremely important question. So the CNIL has not yet adventured there because you're focusing more at this stage on the developers' obligations, not on the outputs. But the ICO published a provisional guidance, which personally seems to me very extremely interesting, saying that what is extremely important is that developers need to set clear expectations for users, whether individuals or organizations, on the accuracy of the output. This is being done from some point of view. If you go to ChatGPT, you will see they have put under the engine, they have put something which could be called disclaimer by some persons. On LinkedIn, a lot of people told me, this is a disclaimer, it does not count the GDPR. For me, it's more of an explainer, because it explains how generative AI works. And it's not a disclaimer, it's information for the user. And in all their policies, all these companies are doing the same thing, and it's better to do it even. But the ICO takes a very strong position, you must inform. And where the problem starts, nonetheless, well, ChatGPT, you can use it for different things. You can use it to correct text, to improve text, to create fiction, to create poems, to create whatever you want. But so all these purposes eventually will not pose any problem, but the problem is that these purposes in all these LLMs are often mixed with other purposes. There is a real intention to give also to function as a research engine and to give summaries to users. So of course you put the disclaimer or explainer, but there are some issues there with the very purposes that the LLMs serve, and we know that the intention is to be used more and more as research engines. So the questions that I wanted to ask here is, how do you see these issues? Jan, I will start with you. Do you think that the GDPR principle of accuracy concerns this specific issue of the output of an LLM and guessing wrongly the birth date of a person? Or is it about something different? And what are your thoughts more generally about this issue?
Well, thanks, Theo. It's not the easier one. But I'd like to question the question. I'm not sure we're talking about the same notion here. I mean, is accuracy has the same notion in the GDPR context and in the AI context? Are we talking about the same thing? Because if it's not the same thing, then it's not a question of applicability. So I would start with the GDPR just to start from the obvious and then go to what means AI accuracy. Under the GDPR, it's true, it's a core principle. Data must be accurate. It's a principle. It comes very early in the GDPR Article 5 and must be kept up to date. I quote, having regard to the purposes for which they were processed. I think so here it's interesting because the purpose is key. Say you have like a historical records of your employees. You keep them because for pension justification, you keep them for 25 to 30 years under some member state law. Maybe this person is no longer there. Maybe he's still working, she's still working, she's not, etc. The data, they are not accurate. They are outdated data, though they are appropriate and you have a legitimate ground to keep it. So I'd like just to say that GDPR notion of accuracy is about facts. It's a factual information. Is it factually true or not? AI accuracy is something completely different. It's not about facts. As you say, it's about predictions, guesses. It's the LLM output about the probability and the statistical accuracy. It's a mathematical likelihood. It's how many and how often the model guesses the correct answer. It's not intended, the intention, the purpose, it's not intended to be treated as a factual information, as a source of factual information about an individual, even if he is or she is very famous. It's about an informed guess, about an individual situation. So it's about prediction. If we agree on that, if we agree all that it's not the same notion because on one hand you have factual information, on the other hand you have informed guesses, then the discussion is no longer whether it's applicable. The question is going to be about the consequences for the people. Is there any harm of the inaccurate output if there is an inaccurate output? Let's say I did the trick, I put my name on one of the LLM, and then I've informed I'm a tax lawyer. I'm very happy to be a tax lawyer. It's completely inaccurate, but I mean, I would be even, it's a very prosperous. There are the rainmakers in our profession. But what's the harm? It's inaccurate. I'm not a tax lawyer, but I'm a lawyer. So you see, the purpose is key. Let's say you use the LLM for entertainment, creative, to write a scenario, a book, a play, a fiction, whatever. Accuracy here is, even about an individual, is not important. There's no harm. It's not the intent. There's no harm. On the contrary, if you use LLM to have a summarize of the patient medical record because you want to be faster and you're going to gain time as a doctor, as a practitioner, and then it's inaccurate, there's a high risk of this inaccuracy, and the harm can be very severe. Same with lesser extent to customer complaints. So, I mean, accuracy is key depending on the purpose. So accuracy at the output depends on the purpose. So it's a contextual answer. And so in that regard, the measures that you have to take into account is the education. So don't think that the LLM is going to provide you with factual information. I think all our friends here from the industry are quite, insisting on that. It's not designed for that. So regarding the individual, you have to be very educational. Regarding the deployer, because the deployer of the AI system is going to be the one who's going to use it for a specific purpose, then you also have to be very clear about the risk and how it's going to use and the harm, but it's going to be on the deployer side. And then you need to have some test and learn phases, otherwise you won't learn from your mistakes. So I think here, like we've said before, that I will end on that. Since context and purpose is key, we must have a journey like we had with the search engine. Like in some instances, you can process some data that you are not allowed. If you're a public figure or not a public figure, if you have a public role or not a public role, the solution will depend on that. I think a contextual approach, an assessment in practice, in light of the purposes and the societal role of the people, like in the right to be forgotten, this notion was created by the court. It's not in the directive nor in the GDPR at that time. I think this is how we should handle the accuracy in principle. Otherwise, there is no solution. We have to be pragmatic, flexible, and focus on the harm and the use rather than on the principle. I think that would be my first reaction on this question.
Thanks a lot. And for me, this goes very much towards the direction of the ICO guidance, which specifically distinguishes between different uses and between the model itself, the APIs, and the application-specific fields. But when we're talking about models as people know them, like ChatGPT or Gemini or the others, the big question is also, and I would like to listen also to the perspectives of the others on this, the fact that an output of an LLM, because of LLMs, ChatGPT pretends also that it gives some accurate, factual information. In the complaint of none of your business, it says that they asked to delete, and they said OpenAI that this would go against the information, the freedom of information and get information about a celebrity. So.
Like the right to be forgotten solution.
This is very interesting, but for instance, if we use ChatGPT or Gemini to create a joke about Kim Kardashian, who is an identifiable person, is this personal data? So that she could accuse us, for instance, of giving inaccurate information. I think that this whole discussion even makes us question, in the LinkedIn field, they said, I used ChatGPT to create fiction. And they said, some people said, even if it creates fiction, it's personal data if it's in that field. So I created a poem for one person who was saying this, and said it was a very flattering poem with ChatGPT and this person. And I said, do you think that this is personal data? As a matter of fact, it's inaccurate. Are you going to complain against OpenAI? And she said, no, because it's flattering, but if it was not flattering, I would complain. So as a matter of fact, William, what do you think about all these issues? And Kim Kardashian is missing.
Which of the 15 questions do you want me to take first? Maybe I can back us up here and start with the purpose of what generative AI technology is. We have to start with AI literacy. We have to start with explaining to people how this technology is to be used, what it's for, and how it differs with the technology they've used before. In your packs, in your packs, we're doing just that. Here's an example of something we would give to teenagers to tell them how to engage with AI generally. I'm not going to go through it all, but I'll read just the 5 headlines out because I think they're important. AI is a machine learning model, not a human. Use it to empower, assist, and inspire you. It can and will make mistakes. Critically evaluate your responses and watch this space as the technology develops, right? The reality of the situation is that AI is prone to hallucination, and whilst there's a deep amount of research going into that, that is the reality of today. It is designed to be a generative experience. And what I would say, and Jan gave an absolutely excellent overview, so I'm not going to repeat all the points he made, but I would draw in on the ICO guidance that's been referenced, which is very clear and I think very helpful in saying it depends on the nature and the purpose of the processing. It doesn't mean that an AI system needs to be 100% statistically accurate to comply with the accuracy principle. In many cases, the outputs, and I quote, of an AI system are not intended to be treated as factual information about the individual. They're there to assist, inspire, and empower you. They're not there to be treated as fact. And investing in that education is something we've done. You referenced the fact we have clear descriptions of what the outputs are intended to be used for in the product. But we know that we have to continue to invest in that education and that literacy as the technology develops and evolves. We also believe it's important to empower users to contribute to improving the models and to actively encourage users to flag inappropriate responses and submit feedback where that's possible. And again, we've created means where users can submit that feedback so that we can adapt the model and adapt the outputs.
Thanks. Jessica, I know that you cannot talk about the complaint against OpenAI, but I wanted to ask you more generally in your discussions with your, do you think that there could be technical solutions to this problem of accuracy in the future? Can we eliminate hallucinations, AI hallucinations altogether?
So while today there isn't a way that we're aware of to eliminate hallucinations, what I'll say is that from a research perspective, we are committed to continuing to improve the factual accuracy of our models. We have published these system cards that I keep mentioning that describe a lot of the work that we've done to improve factual accuracy. And from model to model, it has been getting better and better. And there are third-party studies that have tested, for example, like summarization results and found that the results of all of that improvement in terms of the level of factual accuracy. But it is not a solved problem, and it is something that we are continuing to research, and it's very important area of focus for us, not because ChatGPT should be relied upon as an accurate source of facts, but because it will make the product more useful for people. Because if they are using it to draft text, for example, and everyone should be going and checking and all of that, if it is more accurate, that will make it more useful. And so that continues to be a research goal for the company.
Thanks a lot. And Félicien, I know you have not yet in the CNIL gone towards this direction, but do you have any personal thoughts to share about the same issue?
Yes, indeed, that's right. Since we focused on the development phase, and we're more talking about when this principle applies in the deployment phase, and then everything is kind of linked because you'll have, well, if I think very broadly, you'll have most of the time a developer, system provider, such as the ones we have around the tables, and you'll have also end users or users that will be using the tool. And somehow, well, you have to make sure that the tool that is developed with some specifications and what it can do, what it cannot do, what can be expected, and also that the user on the other end actually uses it correctly regarding of what the tool can or cannot do. So also from the development phase, actually, you have some kind of at least a view on how should the accuracy principle be applied. But then regarding what was just being said, I find both what Tian exposed and also the guidance of the ICO on this principle quite interesting to link it with the purpose. It is obviously a very complicated issue. We're discussing a lot of this internally, so to be seen on our side exactly how we will, but this is an endless debate about what is accuracy, what should be expected, etc.
Well, some people think, though, that they found the solution. This is the next question. And I saw also in the discussions about the Noibe complaint, well, some people said, especially from the activist community, well, it's very easy. You should filter. Or, well, for them, things could be even easier because if you don't collect personal data at all, you know, the problem will be resolved because there will be no outputs about identifiable persons. But otherwise, if you train your model with personal data and you they said that there should be absolutely no reference to identifiable persons. We know that to a certain extent it's already the case. I used to ask ChatGPT about me, and I was receiving flattering response, and now it's not possible anymore because I receive the response that I'm not a famous person, so it will not say anything about me. And as a matter of fact, it still wants to give answers to people about celebrities, not like me. So Kim Kardashian will have a response about her without any doubt. But the activists say, oh, just avoid any reference to identifiable persons. So this would include eventually Kim Kardashian or the President of the United States or Emmanuel Macron.
You can't do that.
I don't know if it will be able to distinguish between living persons and former presidents of the French Republic or the United States. Don't you think that if we enter into this logic of avoiding any reference to identifiable persons in the outputs, this could finally start killing the interest also of these creative machines? As you said, it's very, very creative. So if we push the accuracy to 100% and we exclude another 30% so that there will be absolutely no reference, I will not be able to create a joke about Kim Kardashian anymore because it might think it's personal data, it's about an identifiable person. Don't you think that we might kill innovation while the rest of the world will be moving? What are your thoughts about this? Eventually, Jan, I see you reacting.
Yeah, eventually. You know, it's also related to the question we had on the training data. It's a bit, for me, it's a bit the chicken and the egg. If you want, you know, LLM not to provide individual person output, you must train it to recognize that this is personal data. So how do you do that? If you don't train that this is personal data, he cannot learn, and then he will recreate. So you have to do something about that. So that was on the training data. No, you know, like egg and chicken. I hardly see. I'm not a tech guy, so I wonder if it's possible. Then on the output, here again, I share your concern, Theodore. I think if we had like only LLMs that provide no identifiable person output, I think might kill some things that we have no idea about. So I'd rather, once again follow the path of the ECG in the right to be forgotten when there are different situations because people don't have the same role in the society, in the world. Some are public figures, they have public engagements, and maybe you can do something about you. You can ask Jessica, maybe you can be famous tomorrow. And so, we have to take into account that the public role, is it a public figure, no, and then if it's someone that has a Wikipedia page, it's everywhere in the newspaper, then some of these criteria are objective, then you cannot prevent the model not to provide an output. I think as opposed to someone that is more a private person, then that should be possible. I think it's a proportionality test. As always in law, there's no absolute principle. It's going to be about proportionality. And the proportionality, we take into account your role. Are you a public figure? You express yourself, etc. And then you have expectations. This notion of reasonable expectation. You reasonably expect that you're going to be scrolled on, scrapped, etc., and there's likely to have an output. Unlike if you are not very famous, etc., you are likely to not be in the output. I think this is going to be a proportionality test, so a very case-by-case assessment in light of the context, the purpose, and the role of the person. We won't be able, I think, to have a general ban of not having any output with any identifiable person. I don't believe in it, and I'm sure I wish it.
Anybody else wants to jump in, or you're satisfied by this very human response?
Yeah, doing my best, huh?
Yes, I mean,
Jessica.
I'll just add, I do think it depends on the purpose of the tool. So if the purpose of the tool is to talk about and to be able to discuss world events, then it's going to need to have some of that that ability. If it's going to help the visually impaired and describe images, again, it will also need to be able to deal with that kind of information, translate sentences that also include names. It's going to be able to include that information in order to be a useful tool. But as I mentioned before, when you're training, you want it to learn about the world, not private individuals. And so there are steps that you can take, and we do take, to reduce the processing of personal data, particularly of private individuals. And so even though it does need to learn some personal data in order to be functional, those are the kind of safeguards that we look into. So for example, training the model not to provide private or sensitive information about people, and that's even if the information is available publicly about them, because obviously there is a lot of information publicly available about private individuals as well, but the model's been trained not to provide the private or sensitive information. And so that's a safeguard that's built in order to protect those interests.
Thanks a lot. And let's move now, as time goes by, quickly to the AI Act. How do the GDPR and the AI Act interact in regulating generative AI? It was pretty much complicated for our humans, not to talk about LLMs until now. So now we add another layer of complexity. We published recently, the chair, the AI Act in English and in French with an interactive table of contents, extremely helpful for everybody who wants to navigate the 450 pages of the AI Act. And it is weird because in English people were extremely happy that downloaded these thousands of them, etc. In French also, but in France there was a lot of hate speech against the AI Act, saying it was impossible to read, it was extremely complicated despite the table of contents. And I know that Jan also recently published a very critical article on this. So if you add the complexity of the GDPR with the AI Act, how do things fit together, especially concerning personal data? Now, let's not talk about everything, but what is the interplay, you think, between the two? So, Jan, I think that...
How many hours do I have? No, in a word, how does that play? Poorly. Thanks. No, poorly indeed. I mean, setting the scene, you've said that before, Theodore, that generative AI and LLM, they rely on large sets of data. They need to be fed a large, huge volume in order to train, improve, and have feedback. And at the training and developing phase, there is no specific purpose yet. It's unclear. It's going to be later at the deployment phase. So if you take into these two characteristics and then you move to the principle of the GDPR, there's going to be at least Three issues like data minimization doesn't fly very well with that. Post-post specification doesn't articulate very well with that either. And accuracy, we've discussed that also, so I won't spend. But that's some, three. Like you see that there are structural tension between the two pieces of legislation because they are really built by design, I would say, on that kind of opposite premises. So the way the AI Act solves it depends on if you want to see the bottle half full or half empty. What I like the most is this famous sentence we have in all the European Act is without prejudice. This is a good joke for lawyers. This regulation applies without prejudice of the GDPR. We don't know what it means, but for us it's kind of a lawyer's joke. So you've got two categories of situation where the AI Act did foresee the tension with the GDPR and tried to find a solution. And for instance, I would just provide you with one example I think interesting is that we all know that LLM have risk of being with biased outputs. And like, suppose that on the training data, you have a group of persons that is underrepresented because, I don't know, of their health condition, political opinion, or sexual orientation, or whatever, or ethnical origins, then it's likely that if they are underrepresented in the training data set, then there would be some bias on the output stage. So in order to address that situation, the AI Act states that if you need to process sensitive data, racial, etc., to correct biases, etc., it's possible. It is a derogation in light of the prohibition under the GDPR. So it is interesting that for this purpose of detection biases and remediating them, it's possible to collect this data only for this purpose. I think it's very good because it provides with a new legal ground to process this sensitive data. So that's the bottle half full. Bottle half empty is the definition and the allocations of the responsibilities. Like AI Act is focused on mostly AI providers, and GDPR is mostly focused on data controller. And the two categories, I mean, I don't want to be too long, they do not articulate always very well, especially within time. At the training stage, it's likely that the AI provider is going to be the controller. But at the deployment stage, they're not likely to be the controller. And the controller under the GDPR will not necessarily have the technical knowledge nor the information to fulfill its obligation under the GDPR. And this information are within the provider. So it's poorly articulated. There are some little areas of hopes, but it's quite complex, not let alone the governance piece, which is a maze in itself. This is an attempt to chart the governance piece under the AI Act. In some instances, you may have like 70 authorities competent in one country.
William, quickly, the industry perspective on the interplay between the two.
I mean, look, in 30 seconds, on the privacy side, there are areas of overlap. Clearly, transparency, the use of biometric data in certain training, the use of biometric data, the use of data for bias detection, sensitive data for bias detection in certain contexts. Lots of interesting issues to go into, but we don't have time to do that. And frankly, it's too hot in here, so and everyone wants a glass of water. So maybe I will just say the real change, the real shift is how all of the privacy and governance professionals in this room are going to leverage the opportunity within their companies to take their skills and knowledge of risk management in a privacy context and apply that to some interesting new contexts. So I think the bigger change is not in the text of the AI Act. The bigger change is in the massive structural change we're going to see inside our organizations and the way that shows up for all of us as governance professionals, compliance professionals and lawyers. So I would say the AI Act is the beginning of a process, and the answers will not be found in the text. They will be found in where we are in 5 years' time.
Thanks a lot. And what about the DPA's view on this?
Yeah, well, it's complicated. Well, I mean, it could take quite some time and another panel, and I don't think that's what we want. But as I said, at the EDPB levels, there are some guidance that are being that we work on regarding the interplay of the two texts. And I think it should provide at least a first level of answers. I hope so. Also, I rejoin what said Jan with GDPR. That is a text that is focused on operations, on processes, and the AI Act that is focused on products, on systems, and that's different views on things. And on one hand, you'll have with the AI Act, the providers of the systems and the deployers. On the other one, you'll have the data controller and processor, and then to allocate when a provider is a data controller and when a deployer is one, etc. It's going to take some work. Specifically, I try to go quickly regarding generative AI. I think there's going to be, as said, quite a lot of interactions between various bodies, various regulators. In particular, because it will be done in Brussels through the AI office. I believe DPAs, for instance, as the CNIL, we will obviously deal with large language models that are built in France, such as those built by Mistral, so on and so forth. So regarding data protection, but obviously they will be also regarded in Brussels by the AI office. So we'll have to see how all this will work together. We do hope that we can find some factorization, mutualization, because there's a lot of documentation asked either through GDPR with DPAs, but also in the AI Act through the documentation and also the fundamental rights impact assessments, for instance. So we'll see how it works out, but I hope I believe we can clarify.
Well, precisely, this brings us to the last question, which is...
We can skip that one now.
Which is, if it can appear. Is there any help over there? So the last question, I will ask it like this because there is a sabotage by the organizers, is do you think that all these, precisely the overlapping of all these regulations, could hinder innovation in Europe, including, especially in the field of generative AI? If we compare with the United States, there is almost nothing of all this. Jan, I know that you are critical. Would you like to start? But quickly, because before
we must
ending,
leave
I would
some
like
room
to-
for the
very
question.
quickly. Yeah.
So, well, it's just 2 or 3 remarks. How many times the word innovation is in the GDPR? I think the audience knows the answer. 0. So the good news is that in the AI Act, there are many words and many occurrences of the innovation, and the creation of sandboxes, regulatory sandboxes, I think is a good news. But the problem is that the EU has been over prolific in terms of EU legislation. You've got the Data Act, the DG Act, the EMA, the DSA, the AI Act, etc. And the innovation is a bit lost in translation, if I dare say. So I'm a bit concerned, but I don't want to spend too much time. It's a complex story. The risk-based approach that we are promoting here is not necessarily the one that is taken elsewhere in the world, and we are not the only one playing the AI game in the world. So risk is about precautionary measures, so it's a bit defensive. Other countries see it differently, more offensive, and with more geostrategic issues or industrial or economic issues. But I don't have much time, but just to say that here in Brussels, people believe that the Brussels effect is going to play for the AI Act. I'm less certain of it. I'm hoping for my continent, but in light of the poor drafting, the complexity, and this precautionary measure, I'm not sure this AI Act will fly a long time. That we can have a bet in 5 years' time or 10 years' time. We'll reconvene here and see if it's an operational draft of legislation or if it's already outdated. That's my concern.
William and Jessica, from the industry perspective, and specifically concerning general purpose AI, do you feel that all this...
I'll be very succinct because I think we're over time. I would say that we've long said AI's too important not to regulate well, but I'll maybe end where I began, which is, although it's important to do it well and to be responsible, there's a huge opportunity here for Europe, and we're in a huge moment of technological shift, and we want European consumers, European businesses to get the benefit of that. And above all else, when I look at the profound capabilities of this technology in areas like healthcare, and when I sit down with our engineers and look at some of the things we can do, I hope Europe can move fast and capture the advantage, because I think Europe has a big leadership role to play here. It's playing it by ensuring that it responds to the regulator's agenda quickly, but we also have to help and support that by making sure that Europe gets benefits from the moment in the way that we all want it to.
Jessica, very
You
quickly.
want to skip me for the interest of
Just-
time?
Okay, yeah, for the interest of time. Félicien?
Well, I'll be very quick, but I think the question is, do we think rules are constraining, or do we think they are securing? And actually, well, for us at the CNIL, we do believe that it's actually helping to clarify what you can do, you cannot do. That's what we try to do also, and engage with actors in the AI sector to help them through this. I believe this is the idea, and also I believe it's sometimes easy to say that it's because of regulation that we do not have enough innovation or things like that. I think there are also many other issues at stake.
Thanks. And I don't think that your colleague from ICO will disagree with this. So I will give the floor to Clara for very quickly, just, I'm sorry, for 3 minutes to tell us about the work of ICO on this issue.
Thanks. Sorry, I don't know how this is going to work, but okay, amazing. Well, I think the ICO consultation has been, if anything, overrepresented on this panel, so I don't need to talk too much about it, and I know that we're massively over time as well. I really agree with everything, Félicien, you said. Just to pick up on the legitimate interest, that the interesting question is not so much, is it a valid lawful basis, but how can you make it a valid lawful basis? So some people on the panel talked about benefit of humanity, and kind of, if that's your interest, well, are you sure that it's really manifesting in the deployment? So when you're kind of going through legitimate interests assessments, to not go into the kind of wishful thinking and look specifically at how the product is being used. On the anonymization, I'll just call out that on Friday afternoon there's a panel on that. I'm speaking on it, so come along if you're interested. And then the accuracy principle, I think, honestly, anything I was going to say, Félicien covered it super well, so I don't need to say anything on that. And the final one about outputs and should they avoid personal data, I think that's a classic AI exceptionalism question, and there's no reason other than data subject requests. Of course, there's no reason why GDPR should stop you from doing it. It's kind of a law about how to do things, not a law about how not to do things. So that's everything, but I'm here, and so are my other AI colleagues, so come chat to us.
Thanks a lot, and I'm very sorry, I know there are plenty of interesting questions from the audience. Unfortunately, this is the problem with humans, that we used all our time, and the discussion will continue in Venice, during the previous symposium. Thanks to all for attending, thanks for your interest, and many thanks to our Human Dream team.
Bravo. Bravo à nous.